Let's speak now to Bruce DelValle. He is a constitutional law expert and founding member of the constitutional law and civil litigation firm Fine and DelValle. He joins us from Annapolis, Maryland. Bruce, the Supreme Court has not previously upheld abortion bans before about 24 weeks. How important are those precedents likely to be in the justice's decision-making in this case?
Well, I don't see them as being that important. I think the idea that the viability concept, the viability test originally from Roe v. Wade sort of has taken on a life of its own. When Justice Blackmun wrote the majority opinion, the very contentious majority opinion in Roe v. Wade, he essentially found a constitutional right to privacy. And there had been previously a constitutional right to privacy, but he used that constitutional right to privacy, which, by the way, doesn't exist. It's not written in the Constitution. It's implied. It's what's called a penumbra right. He used that as a way to say that women have a right to determine what happens to their bodies when they get pregnant, as regards pregnancy and abortion. But he balanced the state's desire or power to protect an individual's life. So what he decided was that there's a time when the fetus becomes viable, and when it's viable, the state takes over. And the state can take over if someone's not raising their child properly, if they're not caring for them, if they're not sending them to school, the state can come in and has an interest in protecting that child. So the idea was that there's a time before the fetus is viable, and the original idea was before it could exist outside the womb. Then that's the time that the right of privacy, the woman's individual right, a constitutional right by order of the Supreme Court, the legislated right, not by the legislature, but by the Supreme Court, that the woman has the right to terminate the pregnancy via abortion. So the viability standard is this thing that was invented out of whole cloth, as was the constitutional right. What's happened is scientific advances have taught us or have shown us that that fetuses can survive at a much later date. Originally, it was presumed to be 24 weeks. Now it's down as low as 20 weeks. So the determination of when the state's interest becomes mandatory or primary is the fundamental issue here. There's a single issue here, is whether pre-viability limitations on abortions are constitutional. Both sides recognize that's the only issue. That's the only question presented.
And when we talk a lot about the political leanings of these justices, in particular the conservative-leaning justices, when it comes to these cases on abortion rights. Does politics really play into their decision-making much? Is it possible to keep that out of it?
Well, they are human, and they come to the bench with their ideas. Now, the history of the Supreme Court is the history of justices not doing what you expect them to do. Perhaps the most progressive liberal justice in the history of the court, William Brennan, was considered a shoe-in, lock-solid conservative when Eisenhower appointed him. He didn't end up that way. So a lot of times the justices don't do what you think they do. They do, however, try to get it right. And they do, and they should remember their job is not to legislate. Their job is not to create law. And many opponents of abortion fundamentally and intellectually consider it not only repugnant to their religious beliefs or their morality or whatnot, they see it as judicial activism, as a judge-created law that was created out of whole cloth. Now, the conservative majority is probably going to look at this case different than if they were a liberal majority. But the paragons of judicial legislation have always been the liberal justices and never the conservative justices. So what I expect is going to happen here is they're going to look at the prior case law. They're going to look at Roe v. Wade. I don't think there's much of a chance that they're going to overrule Roe v. Wade. They simply don't do that. They've only overruled perhaps 5 or 6 cases in the 200-plus year history of the court. What they will do, however, is address the viability standard. And there was a case back in 1992. It was called Southeastern Pennsylvania Clinic versus Casey. And what they decided was that they kept Roe v. Wade in place, but they said the states have the right to impose restrictions on abortion as though if they don't unduly burden the person seeking the abortion. And I think that's going to be the linchpin of this decision. I also think, and what you need to know constitutionally is, if this constitutional right of privacy doesn't exist, and it's not written in the Constitution, as I said, then the Constitution is very clear: the states get to decide. And that's the fundamental conservative position. The state should decide abortion. There's only one abortion clinic in the entire state of Mississippi. If Mississippians wanted abortions, there would probably be more abortion clinics. Uh, this is the only abortion clinic in Mississippi.
Right.
So that's one of the fundamental constitutional issues that we have to look at. We've come too far down the road to withdraw, I think, but I think they're going to decide that the question isn't whether Roe v. Wade stands. The question isn't whether there's a constitutional right to privacy and as it relates to what women do with their bodies. The question will be, is this an undue burden? And I will tell you this, Ms. Rubel, that the abortion clinic in question is Jackson Women's Health. The latest that they perform any abortion is at 16 weeks. The new law sets it at 15 weeks. So in reality, all of those people you see on the screen, everyone's saying this is the end of the Republican Party, this is the end of conservatism if Roe v. Wade isn't overturned, or that we've gone back to the dark ages where women have no rights. They're arguing over 1 week. And I think the Supreme Court's going to recognize that. And I predict that they will likely say that that 1 week will not present an undue burden.
Yeah, interesting point there.
And they will uphold the Mississippi law.
Okay. And you said that it's not likely that the Supreme Court would overrule Roe v. Wade, but if the court does uphold this law in Mississippi, what does that likely mean for other similar cases? Does that give them more momentum?
I think it does. I think you'll see other states adopting laws that are very similar to Mississippi's law. And what that does is that further erodes the viability standard. I will also point out that there are 29 states in the United States that have wrongful death, civil and criminal statutes that assign criminal or civil liability for killing a fetus, either purposely or accidentally. And the fetus doesn't have to be 18 weeks old, doesn't have to be 15 weeks old. It's from the point of conception. So you have this oddity where the right to abortion is a fight over viability, but in other aspects of the law, viability isn't even a concept. The idea is if you murder a woman that's pregnant and she's 3 days pregnant, you can be held responsible for murdering that unborn child as well.
Okay.
So it's an interesting, there are a lot of issues here, a lot of moving parts. There's a lot of philosophical, religious, and moral issues. But for right now, I think the Supreme Court is going to escape the political stigma that will come with overruling Roe v. Wade, but I think they're going to uphold the Mississippi statute.
All right. And one thing remains for sure is that it will continue to be a contentious issue in America. Bruce DelValle joining us from Annapolis. Thank you.